That didn't take long. The Biden administration already appealing the ruling. We know that they lost their case. They wanted a court to stay an injunction that stopped them from censoring Americans. We've talked a lot about the big tech government collusion that has been infecting America ever since Trump won the presidency in 2016. But the states sued, Missouri and Louisiana sued the Biden administration and said, your FBI, your DOJ, your CDC are working with the big tech platforms like Facebook and Google and YouTube and Instagram and all of them to censor Americans, and you have to stop doing that. The judge came out and ruled against Biden's, and we read through the full opinion. It was a beautiful opinion by Judge Terry Doughty, and he explained the First Amendment reigns supreme, and the suppression of political speech is a clear violation of the First Amendment. And Joe Biden didn't like that ruling, so they said, can you please hold off on that ruling, stay the ruling while we file this as an appeal? Well, the judge came out today and said, no, we're not going to be allowing that to happen. Your ability to censor is done. And if you don't like it, you can appeal that decision up to the Fifth Circuit. And of course they did. They filed it right away. They say, we must censor or we're all going to die, misinfo and disinfo. And they're very dramatic about it. And so we're going to read through their opinion in a second. But first, let's see what the judge said and why they're appealing this, because the judge issued a whopper of an order. And here's what he said. He said, look, when the government responded and said, Your Honor, can we please just put this injunction on hold so we can continue to censor people? The judge said, no. Here's the judgment on the motion to stay. The case is Missouri versus Joe Biden. One-page order. We'll read the memo in a minute. Coming out of the Western District of Louisiana. Says, it is ordered and adjudged and decreed that the definition of protected free speech shall be amended. The judge is adjusting his ruling a little bit. He says the definition shall be amended, saying that protected free speech means speech which is protected by the Free Speech Clause of the First Amendment of the United States in accordance with the jurisprudence of the United States Supreme Court. Because one of the main arguments that the government was making is, well, we don't really know what free speech means. It's a complicated thing and you're going to micromanage us and what are we going to do? He said it's easy. It's whatever the Supreme Court says. It is further ordered that the government, Biden's motion to stay, the motion to stop my order stopping you, is denied. Oh man, they're not happy about that. So they immediately appealed to the Fifth Circuit. They were saying, can the lower level court, can you just hold it while the higher level court decides? He said, no. If you want this being held off, take it up with them. This is the rationale behind it. He says, your reason is not good enough, therefore it is denied. I have already issued an injunction against the Bidens. It prohibited the Biden administration from contacting social media companies and taking actions for the removal, deletion, suppression of free speech. Bidens don't like that. The judgment defined free speech as stuff that's protected by the court. Now they appealed it. They want us to stop this injunction. The government says, oh no, we'll face irreparable harm every day. The injunction remains in effect because it's too broad and it's too ambiguous and it's going to prevent us, the government, from doing lawful and responsible conduct, like talking to social media companies about removing the grave harm that might befall America. But the judge says, let me give you some law and analysis. He says, my only question here is whether I can make a ruling on the injunction. And he's going through the law. He says, well, is the White House going to succeed on the merits in this case? If I don't grant this injunction, will they win this? He says, no, probably not. He said, we already got evidence on this. The White House digital director, Clark Humphrey, wanted Robert F. Kennedy removed. White House director, Rob Flaherty, wanted Tucker Carlson removed. Surgeon General Eric Waldo, wanted health misinformation removed. The CDC wanted the top COVID accounts removed. All right. The NIAID, Francis Collins, Fauci wanted stuff debunked. FBI met with Homeland. They discussed election misinformation. They pre-butted with the hack and dump and the hack and leak operations. CISA had 5 recurring meetings with social media companies to censor Americans. CISA collaborated with other partnerships, and Jen Easterly wanted our cognitive infrastructure, the way people think, modulated. State Department also was doing the same thing, and the states who are filing this lawsuit have standing. There are individuals who are at harm here, and the government claiming that they're going to be irreparably injured if we don't allow them to continue censoring us. The court says, I disagree with this. These equities don't favor you. The injunction, the government says, is going to prevent them from speaking on matters of public concern. But he says, no, it doesn't. It only prohibits what you have no right to do. All of the other things you have a right to do, you're allowed to do it. But censoring people, free speech is protected. You're not allowed to remove it. The government provided no argument that they're legally allowed to take action on protected political speech. And so the injunction is valid. There are several things that are not prohibited. The government can do all of these things. Specifically in the injunction, you're allowed to work work on criminal activity already illegal, conspiracies, national security threats, extortion, criminal efforts to suppress voting, all already illegal, campaign contributions, actual cyber attacks, actual hacks. But none of this is protected by the First Amendment. And so there is specificity here. They say that they don't know what protected free speech means. They say it's vague because the court doesn't define it. So he says, I'll help define it for you morons over there at the Biden administration. Protected free speech, very easy. Look to the First Amendment. It's the first one if you can find it. And then when you're done there, take a look at the Supreme Court case law. You're not allowed to suppress free speech. And political speech is some of the most protected speech at issue. All of it has already been well defined in the case law. He's referencing several Supreme Court cases. Go take a look if you want to read them. He's telling the Biden administration. And so this is not vague. It's not ambiguous at all. Just read a book. The motion is clearly denied as to the FDA. And so it says plaintiffs are likely, meaning the states are likely to prove that the Biden administration coerced significantly and suppressed Americans in many different domains. Although this injunction involves numerous agencies, it's not as broad as it appears. It only stops the government from doing things they have no legal right to do. Therefore, your request is denied. You are not allowed to continue to censor people while this appeal is pending. And so that's very good news for all of us who want to exist in a country that still adheres to free speech. But the Biden administration, they're not happy about this at all. So they immediately appealed that decision. They say, oh, we have to censor. I mean, otherwise, gosh, I mean, we all might die. So they submitted this. It is 26 pages. We'll hit the highlights out of the Fifth Circuit, automatically filed on July 10th. Boom. Emergency motion. Oh no, America's gonna die. They say here in their table of contents and their introduction, they write, one of the central prerogatives of the president and executive branch is to speak to members of the American public, including companies, about how they can mitigate threats to the nation. From President Kennedy's exhortation for steel companies to lower their prices to President Trump's efforts to encourage companies to keep American jobs on shore, presidents have exercised their power of persuasion. But none of that involves censoring free speech. While the government may not coerce private parties to act on its behalf, courts have set a high threshold for finding that coercion. But here, the district court issued a universal injunction with sweeping language that could be read to prohibit, among other things, virtually any government communication. So dramatic. It's not true. The judge articulated all sorts of things they can talk about. They say the injunction, it prohibits urging, encouraging, pressuring, or inducing in any matter to moderate their content. Again, against taking those actions against legal protected speech. So they say, may federal officials respond to a false story on influential social media accounts with a public statement or a statement to the platforms hosting the accounts refuting the story? May they urge the public to trust neither the story nor the platforms that disseminate it? Yeah, but these weren't public statements. Whack jobs. These were private emails from Rob Flaherty and from Elvis Chan. You're arguing a red herring. This is not the point of this lawsuit. May they answer unsolicited questions from platforms? At this point, I would say no. I mean, no, because you're not qualified to do it. That's my personal opinion. Or consider how the prohibition might apply to law enforcement officials, which were all exempted from the order in the first place. The injunction states the government may inform them, but what if the investigation lacks certainty as to whether a post arises to a level of criminal activity? All of that stuff is lawful. They're creating some red herrings here. They say this injunction threatens to chill the wholly lawful conduct and to place the judiciary in an untenable position of superintending their communications. It raises grave separation of power concerns. And they say the injunction also brings in numerous legal errors. They say social media allows billions of people to share content instantly, which they hate. It's got significant hazards about the spread of harmful misinformation. Platforms have sought to address these hazards to preserve the value of their products, much of these at the behest of you people at the FBI and the Biden team. In March, Twitter amended its content moderation policies in response to COVID-19 to address content, and now Twitter is no longer enforcing those policies. The federal government has sought to mitigate these hazards. The FBI shares data with these platforms, and senior government officials have spoken publicly about the dangers of the rapid spread of falsehoods. And President Biden made some statements about this. On July 4th, this court entered a preliminary injunction saying the states had suffered irreparable harm, and the order states that it does not prevent the government from communicating with the big tech platforms on legal things. But their argument is what you'd expect. They say the states don't have standing, so we'll fast forward through that. They say, nope, they shouldn't even bring this lawsuit in the first place. And they didn't show a First Amendment violation, which is just laughable. The government is entitled to advocate and defend its own policies, but are they allowed to remove other people's speech off the internet? They can express views. Nobody's arguing that. They can can say whether it's false and harmful. But Elvis and Flaherty were asking for removal and threatening and coercing the people on the other side of the phone to do it. So basically they're arguing that it wasn't coercive. All of the other emails, all of the other things that we've covered here are not actually coercive, and the court is misapplying the precedent. None of the 22 examples of coercion that the court, they say, cobbled together from various statements, all plucked out of context, makes any threat. Oh man. The government may gather information and express their policy views. It's not unconstitutional to ask questions like this. How many times can someone show false claims before being removed? Or to express significant concerns about business decisions, like, we're gravely concerned that one of your services is the top drivers of vaccine hesitancy. We're allowed to say all of that. It's not impermissible to request particular posts or accounts be removed, provided that the requests are not backed by threats of sanctions. So they want to continue to be able to do this. Like, they're fighting tooth and nail to be able to have their deputies send emails to the tech companies to have your account removed. They say, we're totally allowed. The government can call a social media company's attention to a doctored video. If you deny us, this is going to limit our ability to do this stuff. Saying the district court erred in some of the other rulings, and the implications of this holding are startling. Wow. Although it's startling that the court told you that you can't break the law, shocking to you? Although the court purported not to decide whether the social media platforms are government actors, it is premised on drawing that connection. So they say, this is to the Fifth Circuit now. Please grant us a stay. The First Amendment is important, but this has not shown to have been a breach of the First Amendment. They said there's no evidence to support a finding that the states are going to face irreparable harm, and this injunction is way overbroad. The district court did not even attempt to justify the breathtaking scope of the relief. It's the First Amendment. They don't have to justify it. It's already been justified and put in there. That abuse of discretion alone justifies a stay. So they're blasting the judge. An injunction so limited would cause irreparable harm to us, the government. It's also vague, and it's going to undermine the public interest. The injunction subjects many communications to a risk of contempt. How could we talk about dangerous misinformation? People will be able to disseminate falsehoods. In conclusion, this injunction should be stayed. We must be allowed to continue to censor. This court should stay the injunction and grant an immediate administrative stay. If the court declines to grant a longer stay, at least give us 10 days to permit the Supreme Court to consider an application for a stay. They're going to take this up to the Supreme Court should the Solicitor General elect to file one. It's such a rotten thing to do, is to use the power of the government to censor your political opponents. It really is an anti-American thing for them to just sit around and say, no, we have the power. If it goes against our policies, your free speech is subordinate to our executive authority from the Biden administration. And they're not just taking this in stride saying, well, we lost in court. They're appealing it to the Fifth Circuit. And if the Fifth Circuit doesn't grant them the stay, then they're going to take it to the Supreme Court. At this stage, we're not even about at the conclusion of the lawsuit. We're just about the stay. We're going to get to the conclusion, but they want to be able to censor for that entire appeal process. And we'll see what the Fifth Circuit says. We're hoping for a good verdict there, but of course, we'll continue to cover.